Next case, please.
David Seeley et al. Versus Geico Advantage Insurance Company.
Good morning, and if you
Good
would,
morning, Your Honor.
if you would kindly introduce yourself.
Your Honor, I'm Subha Gunawardana, a co-plaintiff appellant pro se.
And you're one of the plaintiffs, one of the insureds of Geico who's made the claims against Geico.
Yes.
Thank you. We're very pleased to have you today. Now, I assume the gentleman at council table is
David Seeley,
Mr.
co-plaintiff.
Seeley. All right. Will you be arguing for both of you today?
Yes, I would, and if it becomes necessary, maybe my husband would do the rebuttal.
Okay, he can do the rebuttal. And how much time would you like to
3
receive?
minutes, please. 3 minutes for rebuttal.
3 minutes. Yes, very good. You have the floor. Thank you.
Yes. Well, this case has gone well over 3 years. The record is extensive. We have presented 20 issues for review. Our briefs present complete arguments which we stand by. Here we will highlight just a few key points. First, for at least 4 of the rulings under appeal, the trial court gave no reasoning at all. For other rulings, the court provided some reasoning, but it went against accepted standards, sometimes even against the court's own prior rulings. I'll start with our MSJ on the unconscionable contract and defamation claims. There, our statement of undisputed facts was fully supported with citations to the record. Defendant's response did not cite to the record as required by Rule 5603. They created issues of material dispute solely through affidavits filed at the last minute. They were from previously undisclosed affiants without personal knowledge as required by Rule 5606, and some affidavits contradicted defendant's previous sworn testimony. These affidavits were procedurally improper due to many reasons, not even in addition to what I mentioned. So we moved to strike immediately. The court denied the motion, provided no reasoning. Our statement of facts stands undisputed, but for these improperly filed affidavits. They should have been struck, and our MSJ should have been granted. In that same order, the court granted defendant's MSJ on the defamation claim, stating that our response did not cite to the record. Respectfully, that was incorrect. As shown in the record and stated in our brief, we did cite to the record with each disputed fact. We also stated additional material facts showing issues of dispute, also with citations to the record. Then defendant subsequently moved for summary judgment on the unconscionable contract claim. That was granted. There are several errors with that ruling, both procedural and substantive. First, defendant's affidavits there were also inadmissible due to several reasons. We presented detailed objections. Trial court did not address or even mention our objections. Without the affidavits, defendant's statement of facts would be unsupported. The court erred by not determining the admissibility of affidavits first, as is the standard for summary judgments. Defendant's statement of facts was supported solely by these 2 affidavits, both of which contradicted their previous sworn testimony. One affiant was completely new and was not properly disclosed under Rules 26 and 37. Despite our timely request, we did not get enough time to depose this witness properly and to properly respond to the motion. Even considering these affidavits, summary judgment is still erroneous because several reasons. Defendant had presented a new defense here, lack of standing. First, this defense was untimely. Standing is an issue to be presented early on in a responsive pleading, like a motion to dismiss, not at this late stage. Interestingly, standing was never brought up before by the defendant or by the court, like when we moved for summary judgment on the same contract claim. Even if considered, standing is not applicable here. This claim we brought under contract law, unconscionable contract, not under TCA 56.7.1109.
What makes this contract unconscionable?
There are several reasons. The contract under the contract in question is the Geico's rating plan. It has a list of exceptions for qualifying accidents, at-fault accidents, which would increase rates. But under these exceptions, rates would not increase despite a qualifying accident. So as required by this statute, lack of negligence is one of those exceptions. Number 10, the statute intended this exception for all drivers, but Geico limits this exception only for those driving under employer-employee capacity and excludes those driving in a personal capacity. So Geico's explanation for this was that the rating plan is compliant with the statute because the exceptions to qualifying accidents are applicable only in circumstances in which the insured is not at fault or negligent. But this statement is false because nowhere in the rating plan does it state that the exceptions are applicable only when the insured is not at fault or negligent. Not only that, some exceptions apply even with negligence. Exceptions 8 and 9 for first responders and government employees, those people are accepted unconditionally, even with negligence. So lack of negligence should be an exception for everybody, but Geico excludes personal drivers from that exception that the statute intended. And also here Geico implies that at fault and negligent are the same thing, but it is not. The rating plan does not define these terms. Lack of negligence is just one of the exceptions to qualifying accidents. So clearly these two terms are not the same. So it excludes the protection required by the statute.
How is that applicable here? If this understanding is correct, then how is it applicable in a circumstance where Geico says there is fault in this case?
If there is fault, then it should be it would not apply. However, lack of negligence is one of the exceptions. And when there is no negligence, the exception should apply. But under this contract, regardless of whether there was negligence or not, personal drivers do not get an exception even when there is no negligence. So when they raised our rates, they just pointed to the contract because it doesn't have an exception for personal drivers. So even if you can prove lack of negligence, it doesn't matter, your rates increase. This is explained. We explained this in great detail in both in our brief and in our motion for summary judgment and in our response to their motion for summary judgment. Granting summary judgment is erroneous, and also the court did not analyze the contract under the proper standard. That contract must be interpreted as written. Contract is unconscionable on its face, as I just explained. Defendant presented a different interpretation through affidavit. It was a convoluted interpretation, as I just described. That interpretation uses terminology that was not present in the contract. The court never analyzed the contract. The court ruled for defendant relying solely on the affidavits. Interestingly, the court previously denied summary judgment to us, citing dual interpretations of the written contract. When subsequently presented with the same dual interpretations, the court granted summary judgment to defendant. So that disregards the widely accepted standards in contract interpretation, and it also goes against the same court's same prior ruling in Artist Building Partners, where the court interpreted the contract on its face without the need for experts or affidavits. I will also touch on the dismissal of some claims with prejudice. 3 of our claims were dismissed based on defendant's motion to dismiss. It was also procedurally improper, and even if accepted, it should not have been substantively granted, particularly on the FCRA and bad faith claims, because these claims were not futile. The court never considered our proposed amended complaint. The court denied leave, stating that no amendment is allowed without setting aside the previous dismissal. But we did move to alter or amend the dismissal immediately after the dismissal. The court never formally ruled on that motion to alter or amend, nor addressed the arguments therein. The dismissal should have been set aside because the amendment was not futile. And finally, there is no rule stating that a dismissal must be set aside before granting leave to amend non-futile claims. The standard the court relied on here, Lee and others, they are not applicable here, because in those cases, the proposed amendments were futile and or the plaintiffs had not properly moved to amend the complaint. Here, the amendment is far from futile, and we had timely filed a Rule 15 motion with the proposed amendment attached. So even Lee recognized that amendment should be granted. Tennessee law and policy have always favored permitting litigants to amend their pleadings to enable disputes to be resolved on their merits rather than legal technicalities. Here, our claims were dismissed based solely on legal technicalities, not merits. So the applicable standard is Freeman, which we cited, and Richland, it stated that when courts grant a motion to dismiss for failure to state a claim, only extraordinary circumstances would prohibit a plaintiff from exercising the right to amend. And this decision also contradicts the court's own prior ruling in Dajani, where he allowed a plaintiff to amend once without setting it aside. Respectfully, we also believe that defendant had waived several challenges, their challenge to several issues, by not designating them in their response brief. Defendant's statement of issues does not designate several key issues. It also omits facts and misrepresents issues. For example, it does not mention our motion to strike or the court's failure to provide reasoning for several rulings. So that is my time.
All right, thank you. We'll hear from you on rebuttal. We'll now hear from Geico. Good morning.
Jamie Lever for Geico Advantage Insurance Company with Benton Patton, but I'll be the only one arguing this morning.
Very good.
Your Honors, this case stems from, and I think it's important to have some sort of factual understanding as to what actually happened and how all of these claims came about. This lawsuit stems from a motor vehicle accident where Mr. Seeley backed into another vehicle in a McDonald's parking lot in February of 2018. At the time, they had an automobile insurance policy through Geico. They called Geico, reported the accident. Geico talked to them. Geico talked to the claimant. At no point did anybody mention any sort of brake malfunction. 4 months after this accident happened, in June of 2018, the plaintiffs claimed for the first time that this accident was caused by a brake malfunction. So all of their claims against Geico in this lawsuit stem from their position that they were not at fault for this accident because of this brake malfunction. And the one thing I want to address briefly that they brought up is the issues that we didn't include in our brief on appeal, but Rule 27B of the appellate procedure doesn't require that we include our own statement of issues unless we have any issues with theirs, which is what we did and reframed those. Their claim for bad faith, the law in Tennessee is very clear that Tennessee does not recognize the tort of bad faith in suits between an insured and an insurer. Geico made this argument when it sought dismissal of that claim, and in response to that, for the very first time, they made a choice of law argument that this claim should instead be governed by the laws of Missouri. That was not in their complaint. It was not properly before the court when ruling on the motion to dismiss, but the court addressed it nonetheless and determined still that this claim was governed by the laws of the state of Tennessee. The state of Tennessee does not recognize this specific cause of action, and it was properly dismissed. They had an additional bad faith claim, a statutory bad faith claim under 56-7105, which is the bad faith failure to pay statute. And that statute is applicable only when an insurer fails to make a payment. Their complaint has no allegation at all that Geico failed to make a payment, and in fact says the exact opposite and admits that Geico paid the claimant's claim. Their argument as to why this statute should be applicable is because Geico essentially failed to pay when they increased their premiums and recouped their losses. That is not sufficient to state a claim under the bad faith failure to pay statute. Bad faith failure to pay means exactly that. It means a failure to pay. They did not make that allegation, and that claim was properly dismissed.
Now, in this case, the driver of the other vehicle, Miss Wegman, Geico paid for her damages to her car.
Yes, Your Honor, and you will see that they admit that in the complaint as well. As to the Tennessee Consumer Protection Act claim, they didn't bring up any sort of argument about that in their brief on appeal. I believe that that issue has been waived. They haven't done anything other than just make a brief reference to it, but that claim was also properly dismissed by the trial court. The Fair Credit Reporting Act claim was also dismissed in response to our motion to dismiss because plaintiff's complaint stated a cause of action under 1681 IA5. This statute applies solely to consumer reporting agencies. Geico is not a consumer reporting agency. Plaintiffs made no allegation in their complaint that Geico was a consumer reporting agency. And if Geico is not a consumer reporting agency and they haven't even so much as alleged that that is the case, then they cannot pursue a claim under this provision of the Fair Credit Reporting Act that applies solely to consumer reporting agencies. After those three claims were dismissed on the motion to dismiss, they did seek to amend, and they've alleged that the court was wrong in denying that motion to amend the complaint because the amendments weren't futile. The amendments that they sought included claims that the court had already dismissed because they determined that they lacked merit. I believe that more than qualifies as a futile claim if the court has already determined that it hasn't stated a cause of action. As to the other claims that they sought to amend, they relied upon the exact same facts that they knew at the time they filed their complaint. They didn't change any of the facts. They just changed a little bit of the wording that would not overcome the dismissal because the claims failed as a matter of law. So all of the claims that they were seeking to amend would have failed as a matter of law, which makes them obviously futile. And the court's determination that the motion should not be granted because the claims were futile was appropriate, and also because a lot of them were not timely. They had filed a second motion to amend several months later, requesting to amend their complaint to allege certain allegations related to their defamation claim. The court determined that this case was already set for trial. The timeline for discovery has already passed. You have done this way too late in the litigation, and the undue delay alone is sufficient to preclude granting this motion. Even so, though, the court stated that I'll still allow you to present some sort of evidence as to malice or intent to injure, but I'm not going to let you amend your complaint this late in the litigation.
Counsel, the publication for purposes of defamation was the credit report, right?
It was an at-fault determination that Geico made that was then placed in a CLUE, which is the Comprehensive Loss and Underwriting Exchange Program report. And I believe there were two different reports that were reflecting an at-fault entry. So yes, Your Honor, that is correct. So as to the defamation claim, which again is based on the allegation that Geico falsely reported this accident as at fault, plaintiffs had to obviously prove that a false statement was made with knowledge that it was false or with reckless disregard for the truth. There were two competing motions on the defamation claim. Their argument is that the court's denial of their motion was an error because it improperly considered that the affidavits we filed in response to the motion for summary judgment. Those affidavits included an affidavit from John Leachty, who is an expert professional engineer, who provided an opinion that the brake failure did not cause the accident because the vehicle was set up in such a way that had the front brakes failed, the back brakes would not have failed, so it couldn't have possibly caused this accident. We provided an additional affidavit from Alex Horton, who at the time was a representative of Geico, who stated that at no time up until 4 months post-accident did they claim that this accident was caused by a brake malfunction. We asked them to provide us proof of that. We looked at what they provided us, determined that our at-fault determination was correct, and we were not going to change that. So the court properly determined that there was obviously a material dispute of fact as to whether or not that statement was false. And their main argument as to Alex Horton's affidavit is that it was improper for Geico to attach an affidavit from Alex Horton in response to this motion for summary judgment, and then later claim that he was not a corporate representative when they filed their motion to quash. Geico never claimed that Alex Horton was not a corporate representative. The motion to quash was filed because plaintiffs failed to comply with Rule 30.02. They didn't do it properly. They didn't follow the rule. We filed the motion, which outlined what they needed to do to comply with that, to notice a corporate representative for a deposition, and they failed to file a new one to do that. So the only error there, it was not that Geico was claiming one thing in this affidavit with Alex Horton and another in filing the motion to quash. The error was that they didn't comply with Rule 30 in noticing the deposition, and they did nothing at all to attempt to rectify that so that they could take a corporate representative's deposition. The defamation claim, aside from the fact that the facts were disputed sufficient to overcome their motion for summary judgment, is preempted by the Fair Credit Reporting Act. The duty of furnishers of information, so Geico would be a furnisher of information, to supply accurate information is governed by 1681 S2 of the Fair Credit Reporting Act, which states that all state law claims that involve any subject matter regulated under this section of the Fair Credit Reporting Act, and the furnishing of information would be governed under that provision, are preempted unless the information was furnished with malice or willful intent to injure. Plaintiffs made no allegation in their complaint of malice or willful intent to injure. Their argument is that the court was wrong in determining that there was no malice because it can be gleaned from this circumstantial evidence that Geico failed to remove an at-fault entry after they reported it to them. Malice is, and the court stated this in its order, evil intent or motive arising from spite or ill will. The evidence that they have presented, the circumstantial evidence that they've presented, is not sufficient for a finding of malice or willful intent to injure, and without any allegation or proof of that, the defamation claim is preempted by the Fair Credit Reporting Act. The unconscionable contract claim, there was one issue before the court on that claim, and that's whether or not Geico's rating plan complied with Tennessee Code Annotated 56.7.1109. In support of their motion on that claim, they relied solely on their interpretation of the statute. They filed affidavits in support of their motion saying it's our interpretation, it's our opinion that this does not comply with 56.7.1109. To dispute that, again, we filed affidavits from Robin Bain and Ashley Snyder. Robin Bain works for the Tennessee Department of Commerce and Insurance, and she provided an affidavit that stated the Tennessee Department of Commerce and Insurance looked at this rating plan, they determined that it complied with law, and it complies with 56.7.1109, and we approved it. The affidavit of Ashley Schneider stated the position that Geico has been taking all along as to what this rating plan actually says, and that is that the definition of a qualifying accident in the rating plan first requires, before any exceptions even apply, a determination of fault. So while there is not that exact language that they are claiming is missing from the statute, that qualifying language at the beginning makes it very clear that that exception doesn't apply unless there is a determination of fault or negligence. So the rating plan does not permit an increase in premiums if there is no finding of fault or negligence because of that qualifying language at the beginning. Those affidavits obviously created a genuine dispute of material fact in response to plaintiff's motion as to whether or not this contract complies with 56.7.1109. Geico then filed their own motion for summary judgment on the unconscionable contract claim, arguing two separate issues. One, they don't have any standing to bring a claim for an unconscionable contract because the law does not permit a private cause of action under 56.7.1109. They have argued that standing is irrelevant because their claim was brought under contract laws and not 56.7.1109. But if you look at their complaint specifically states that Geico created an unconscionable contract in violation of 56.7.1109. Their claim is specifically made under that statute and was analyzed appropriately, and the law is clear that there is no private right of action under 56.7.1109.
Counsel, I have a question about terminology there. Is standing the word that we should be using here, or is this more zone of interest or simply statutory inapplicability?
So, and Your Honor, I am using standing because that is the word that the trial court used, but to give you a little bit more as to what specifically that means is that the statute does not permit a private cause of action because there are no express terms in the statute that permit an individual to bring a private cause of action because the statute is primarily penal and regulatory in nature, and that there is no implication through the statute structure and legislative history that a private cause of action would be permitted. And
Counsel, would you disagree that there are some appellate courts that suggested that trial courts and appellate courts should stay away from the use of standing in that type of context and instead refer to it as zone of interest or simply inapplicability of the statute rather than standing, because standing has its own meaning?
And I understand that, Your Honor, and like I said, that's how the court had been interpreting it, so I was trying to keep the language somewhat consistent, but the issue is that the statute itself does not permit a private cause of action. So if that answers your question, to enforce a statutory duty, they have to show that the legislature intended for a private right of action to exist, and they haven't done that. The court, in ruling on the unconscionable contract motion for summary judgment that Geico filed, also determined that there was no dispute of material fact that the rating plan did comply because the affidavit of Robin Bain from the Tennessee Department of Commerce and Insurance, who stated that we approved this, it complies. They did not dispute that with any cites to the record. I know that they had mentioned that, but their citations or their response to those facts were, we disagree with that, that is wrong. A conclusory allegation is not a citation to the record that's sufficient to dispute a material fact, and that is all that they provided in response to that motion. While that motion was pending, they had also filed the motion for extension of time to respond to depose this individual. The court properly determined that she'd unequivocally stated that this complies. You're not going to get any information to dispute this by taking her deposition, and I see I've got about 5 seconds left. And you'll note too, just briefly, that the record is devoid of any attempt by them to even try and take her deposition, but now they're claiming that they were prevented from an opportunity to respond because they couldn't do that when they didn't even try and do that in the time that they did have.
All right.
Thank you, Your Honor.
Thank you very much. We'll hear from rebuttal. Mr. Seeley. Good morning.
I'm David Seeley. Thank you. They referred to the accident in question. We did inform Geico of the brake failure on the day in question. We submitted the accident report. In the accident report, it mentions the brake failure. Geico failed to investigate it. We asked for tapes. They record everything in deposition and discovery. They refused to give us those tapes. They knew about the brake failure from the get-go, but they refused to investigate it. According to their contract, they don't have to investigate brake failure, because once they determine that an individual is not driving in the capacity of employed, what we found out in discovery is that an individual does not decide whether or not you are at fault. It's a computer program, and the computer program just determined, once they click that thing that says, "Oh, they're not driving in that capacity," you're automatically at fault. And
You're saying that Geico has a computer program that says if you're not driving as an employee, you're at fault?
well, there's nothing that says that unless there's some other operand, you are automatically at fault. There's nothing there that says that you are not at fault.
And you have evidence in this record that says that?
We provided evidence from they gave us in discovery that of that software program that they used.
Okay.
Mr. Sibley, did you bring a breach of contract claim that simply they violated the insurance policy itself in this case?
We wanted to amend the complaint, but we were not allowed to.
So that's part of your attempt to amend the complaint?
Yes,
a
sir.
breach of contract?
Yes, Your Honor. When she was referring to the tort of bad faith, we did ask for to address the choice of law. There's nothing I couldn't find any case law that says there's a time limit to bring forth choice of law. I found many cases, and we cited them in opposition to their motion to dismiss, that the proper vehicle is in opposition to a motion to dismiss, to bring a choice of law argument.
What evidence did you present to suggest that a state other than Tennessee should be the choice of law?
That because Tennessee came to the conclusion, we disagree with the court that that it's contract is, they think it's the contract is lex
loci.
Contractus. But the courts came to the conclusion that it's the significant relationship test. And according to even some of the case law that we cited in our brief, that because the accident occurred in Missouri, the claims happened in Missouri, the decision happened in Missouri, everything, the most significant relationship would be in Missouri. So therefore, their law should hold in that.
All right. Thank you, sir. Your time is up, but thank you, both of the appellants, for their arguments, and Geico's counsel, and we'll take this matter under advisement. That concludes the morning docket.
All rise.